Senate Bill 992 by Senator Taylor, and at this time recognizes Representative Sheets to explain the bill.
Thank you, Mr. Chairman. Before I begin, I had the honor of last session authoring the bath salts bill with Representative Coleman and getting that through, and so it was good to sit here while to hear Representative Perry's bill come through and see, because that is a problem. Even though we tried to get the substance into the controlled substance category, we did. They've already changed the formulas and are working around it. So, and with that, Mr. Chairman, again, and members, I appreciate your giving me the opportunity to lay out Senate Bill 992 before the committee. I apologize that it is a Senate bill, but sometimes we have to hear the other chamber's bills. In order to ensure that their patients who have been prescribed pain medications are taking appropriate doses and not doctor shopping to obtain multiple prescriptions for sale or use, many pain physicians utilize urine drug screening tests, or UDT. A UDT that shows a patient does not have a prescribed drug in his or her system may indicate that the patient is diverting drugs for sale. Likewise, these tests can help physicians determine whether inappropriate levels of prescription and or illicit drugs are in the patient's system. A UDT administered in a physician's office is commonly called a point-of-care test or cup test and can be used to produce qualitative test results. This means that these tests can produce a yes or no response to determine the presence of certain drug classes. These tests produce statistically significant number of false negatives and false positives. Physicians may also utilize benchtop analyzers, which, much like qualitative tests, are used to determine the mere presence or absence of a specified substance. In order to properly identify and quantify each specific drug in a specimen, physicians send specimens for confirmatory testing to laboratories that utilize mass spectrometry gas chromatography tests to produce quantitative results. And I used to be a defense attorney, so I should be able to say those words. Interested parties contend that some manufacturers or sellers of benchtop analyzers market the devices to physicians in a deceptive manner by indicating that the devices will produce a quantitative result. In some cases, misrepresentation of a device may lead to inaccurate billing procedures by providers and result in erroneous reimbursement costs associated with testing. Senate Bill 992 amends the Penal Code to specify that a manufacturer or seller of drug testing equipment is committing a deceptive business practice if they represent that the equipment is capable of returning quantitative drug test results unless it has been approved by the United States Food and Drug Administration. Senate Bill 992 also provides that the offenses under the new subsection constitute a Class C misdemeanor. This bill went through the Senate without any opposition. We learned of some opposition this morning, and they are testifying, so they'll be available for the members to ask questions. And then we also have witnesses available to testify for the bill. And with that, Mr. Chairman, if there are no questions, I reserve the right to close.
Questions, members? Thank you, Representative Sheets.
Thank you, Mr. Chairman.
Chair acknowledges that Representative Sheets has reserved the right to close on Senate Bill 992, and at this time the chair calls Richard Evans with Millennium Laboratories wishing to come forward to testify for House Senate Bill 992.
Good evening, Mr. Chairman and members. I'm Richard Evans with Texas Lobby Solutions representing Millennium Labs. I appreciate the opportunity to come and testify before you. I've got a handout here that I'd like to show. I think Representative Sheets covered the issue pretty well. Millennium Labs is one of the confirmatory labs that does the quantitative testing on behalf of a lot of pain physicians. 4. Yes, sorry. In favor of the bill, yes. Sorry. As much of a problem as was just described with the previous bill, prescription drugs are a huge problem in Texas too. And you all passed some really good legislation in the last couple of sessions to regulate pain management clinics and to improve the prescription drug monitoring program in Texas to really try to get an idea about controlling those prescription drug abuse problems. For doctors that deal with patients with chronic pain, the standard of care really requires them to do some periodic testing of the patients. And it's usually based on risk stratification. So if you've got somebody who's had drug abuse problems in the past, they're going to get tested more. If you have an 80-year-old grandma who's just had her first pain med, she's probably going to get tested occasionally or maybe never. The doctors will use a cup test in the office. We've all seen a little cup you urinate in and sent off to the lab for test results. So the doctor can actually just read it there, and you can get an indication of, is something present, is it not present. There are a lot of false negatives and positives with that. So those are typically, just a good indication. Is there some cocaine in the system? Is there hydrocodone in the system? And I've prescribed that. So you get an idea about yes or no on those. Then you've got semi-quantitative testing, which is better than point of care. It's with a machine called benchtop analyzers, and you can get a little bit more information about the drug class and a numerical result off of that. But both of those tests recommend that they also be sent out to labs for confirmatory testing. So you get those point of care or semi-quantitative results from the doctor. They're sent off to a confirmation lab that runs a test. It's a quantitative test with liquid chromatography and mass spectrometry to really identify the exact drug and the amount of the drug that's in the specimen. And that's returned back to the doctor. Our lab does in about 18 or 19 hours. One of the problems that we've seen cropping up around the country is that some device companies are marketing their devices in a deceptive manner. There's nothing wrong with using the semi-quantitative device. It's better than point of care. We would encourage doctors to use that test, but it can't produce the same result as a machine that does a quantitative testing. One of the issues that's come up here in Texas over the last year or two is the document that I handed out to you is a banner message from our state Medicaid office that is a message out to healthcare providers in the Medicaid system telling them that billing for a quantitative code, which pays more than a qualitative or semi-quantitative, is inappropriate. It's systematic upcoding. It makes them subject to administrative violation and potentially civil penalties. There was also a notice out from Trailblazer, which was the Medicare intermediary here in Texas. So it's a growing problem. Government payers have seen that as a problem, and all the bill does is say that you can't misrepresent to a consumer, in this case a healthcare provider, that they can purchase this device and bill for a quantitative test when the device isn't cleared to produce that kind of test.
Representative Schaefer. Oh, I'm sorry, Representative Tiller.
Right. So you have a vested interest in people not using these devices?
Actually, not so much. The way that the process works,
these devices compete against you, don't they?
Not really. The devices, both the qualitative cup test and the semi-quantitative test, typically will be sent out for confirmatory testing to a lab like my clients.
Right.
Because the test won't give you the level of detail that you get with a quantitative test. And you're not going to do that for every patient. But if you get a false negative or a false positive that you think is fishy and you want to send that out for more analysis.
Do you have any literature that you can show us of false advertising?
I do have some information that I can provide to each of you individually, yes.
That'd really be helpful. It's just... Yeah.
Yeah. And there are some companies that have popped up just in the last few hours that are opposing the bill. They're claiming that we're trying to stop semi-quantitative testing, and that's not the case. That is a better test than
Can you show us
a cup test.
some records of some some false billing records, anything at all to substantiate what you're saying?
Actually, the Medicaid office that put out the banner message is probably the better office to ask for those kind of inappropriate billing because the doctors are billing.
I get that, but is it one office that's done this? Is this widespread going on all over Texas? Or?
Yeah. Our company operates in all 50 states, and we've seen this in several states where the device is being sold. And not only is it an issue that the device won't return the results that they're claiming, but when you have a physician that is now the owner of that device, utilization typically goes up because now they're billing for it and getting paid for it. When they send the test out to a confirmatory lab, they tell us what to test for, and then we bill the payer. And there's no financial interest in the doctor ordering tests that aren't necessary. But when you have a financial incentive to do the testing and bill for it, you test a lot more often for a lot more substances on a lot more people. So You've got both. You're not getting good results, and you're driving up utilization when they own the device. And again, it doesn't do anything to stop anyone from selling the device. They just shouldn't market it in a way that's deceptive.
Representative Canales?
But is it, I mean, in your opinion, is it necessary to make it a crime?
Well, it's amending the Penal Code of the Deceptive Trade section, which already has a laundry list of things that are deceptive trade practices that are subject to the Penal Code.
I mean, for instance, I was having a child. They've got a deal at the Walgreens that says it can tell me whether my wife's going to have a boy or a girl, and it's not FDA approved, and they say that it can do it. I mean, you know, it's not a crime. Wouldn't you think that the market can regulate this? That the people that are looking at whoever's selling this thing, if this is you're the government or you're a city or an employer, that you would look to make sure that whoever you're getting tested by is actually a real test?
I would say,
and you look into it yourself to make sure you're validating, because if you're drug testing somebody, it's obviously of importance to you. Would you agree?
Absolutely.
Okay, then wouldn't you agree that that person is also going to look to see who and what kind of test, without having up for us, the legislature, to make it a crime?
I would assume that if they're not a chemist or a doctor, they probably aren't going to understand what the test process is and what the results mean.
I'm not a chemist or a doctor, and I think that I should be able to talk to somebody and say, what are you selling, and tell me how it works, and tell me what are your qualifications. I appreciate you being here. I just don't think this is something the legislature needs to make a crime out of. Thanks. Appreciate you being here.
Sure. Thank you.
Representative Toth?
No, I mean, Terry covered it really well. I just, for us to add something to the penal code to make it a crime for this, when it's just, we haven't seen any business products, we haven't seen any brochures, we haven't seen anything. I mean, it just...
Well, then we'll produce those for you, and be happy to give those to the clerk and have those distributed to the staff.
Yes, please.
Sure.
All right. Thank you, Mr. Evans. Chair now calls Stephen Barrett with the Carolina Chemistries, wishing to come forward to testify against Senate Bill 992. If you would, come forward, state your name, who you're with, and what your position is with respect to Senate Bill 992, please, sir.
My name is Stephen Barrett. I'm Regional Manager for Carolina Chemistries. I've about 35 years experience working in the lab, marketing laboratory equipment to physicians. I've sold chemistry analyzers to physicians for several large national companies, Roche, Elon, Toso, a variety of the larger companies. I live and work in Plano, Texas, so I am a Texas resident. And I oppose SB 992. SB 992 is bad for all concerned. It's bad for the physician and bad for the patients and bad for the state of Texas. I'd like to tell you how I heard about this bill. A competitor was using this potential legislation as a sales tactic to squash competition and push their product. And I found out about it last week, and one of my physicians sent me this that he had gotten from a competitor of mine. We're also hearing reports that some physicians are being discouraged with this potential legislation from setting up their own laboratories. They'd like you to believe that all urine screening tests, UDTs, are the same. They simply aren't. There's a significant difference between qualitative cup technology and the innovative technology that we provide. Our equipment provides a number that can be set up in a qualitative mode or a semi-quantitative mode. So you can set it up in either mode. So the physician has a choice on what he wants to do depending on his own individual requirements for his lab. When used in a semi-quantitative mode, the results is in nanograms per ml and is far greater utility than a qualitative cup technology that often requires expensive confirmatory testing provided by the firm that I think is pushing this bill. So why is SB 992 bad for the physicians and patients? The bill would limit a physician's ability to run a more accurate immunoassay instrument for urine drug testing. It would force the physician into a protocol for testing that is unreliable, requiring expensive secondary testing, costing the state more money, insurance companies more money, and creating a hefty burden for the uninsured. If this bill passes, the only way a physician can obtain a quick result is to use a qualitative cup that has a false negative rate as high as 80% when used in pain management clinics. This technology was designed for law enforcement and forensics, not pain management. It forces the physician and the patient to have to wait as long as 2 to 3 days for a confirmed result because the cup was negative. This delays treatment decisions by the physician and causes undue stress on the patient. Why is it bad for a state? The bill will force taxpayers to foot the bill for unreliable qualitative cups plus their costly confirmations. It will hamper an innovative technology and stifle competition. SB 992 is bad for all concerned. It's bad for the physicians, bad for patients, and bad for the state of Texas. I respectfully request that you vote no on SB 992.
Representative Canales?
Are you in this business?
Yes, I am in this business.
How hard is it to get the FDA to? My understanding is it's terribly hard to get the FDA to approve something. Is it?
It is.
Okay. It's obviously not a food. How is this a drug?
It's not a drug. It's a drug testing methodology.
No, I understand what it does. I know the Food and Drug Administration, so this falls under their purview.
Yeah, we're FDA approved for semi-quantitative and qualitative assays.
Okay, so this is like to get approved is a huge deal.
Yeah, and not only to get approved is it a large deal. The state of Texas inspects the laboratories and requires certain requirements, for reliability.
The state's already checking.
Yes.
So, thank you.
Representative Toth?
So it's FDA approved.
Yes.
I can't understand why you don't want us to hold doctors accountable for how they use your equipment.
It's up to a doctor's own. It's just like.
I'm kidding you. But.
Well, yeah.
10 o'clock at night.
Well, you guys still scare me a lot, so I don't take any jokes up here.
I do that. So, no, it's an FDA-approved piece of equipment. I used to work for a pharmaceutical company. How a doctor chooses to use something, that's a matter of his character and integrity if he has any. But I don't get this legislation.
Well, the utilization aspect of it, the reason a lot of physicians will increase their utilization, and it's a good thing, because prior to this they weren't able to get the results back in a timely fashion, so they just had to take a chance. And now they've got the capabilities of running these assays in-house and actually seeing the results in a timely fashion and actually, use that information.
Thank you, Mr. Barrett.
Thank you.
Hold on. Representative Carter?
Hi, thank you. Okay, I have a couple of quick questions. So, and I'm sorry because I missed some of the early testimony.
Sure.
I was grabbing a bite to eat. We don't get breaks, as you know. So, okay, I'm reading language in the bill. Manufacturing, selling, or attempting to sell a drug testing device or equipment and representing that the device or equipment is capable of or certified for returning quantitative drug test results if that equipment has not been approved by the FDA to perform such quantitative testing. So my read on that is basically if you have a piece of equipment that is not FDA approved and you're testing it for some sort of quantitative drug test result, then the device is capable of or certified for, and you're representing that, then you probably shouldn't be representing that it's certified for returning quantitative drug results if it's not FDA approved. Is that your understanding of what?
Yeah, we say it's semi-quantitative or qualitative. There's two options that the physician can take.
Okay, and I might have missed this, so I apologize. So semi-qualitative, is that what you said?
Yes.
Or what was the second option?
Qualitative.
Qualitative, okay. And so with that, and I'm so sorry, I might have missed this, but how does that fit into this item 13? If you say it's semi or qualitative, then does that mean that you are committing an offense or not?
No, we're not committing an offense.
Okay. So if you're not committing an offense under this, your opposition is just that this is just making it harder. You're not going to be in that category to whom this would be applicable, but in your view, this would make it harder for you to do your job. But wouldn't you argue, on the other hand, that because you are, in essence, not committing an offense, you don't want people to sell equipment and certify that this equipment is actually producing some sort of quantitative drug testing result, right, when it hasn't? In other words, misrepresenting in some regards. It reminds me, Representative Sheets, of like a DTPA claim or something. But so am I missing something here? I think I am. So why would you, I guess my question is, you were asking as a joke. I was kind of wondering, like, yeah, that's true. Why, and I'm so sorry, but why
That's
would
okay.
you be opposed to, if you have a piece of equipment that doesn't certify a particular type of drug testing result, and you're representing it as such, but it doesn't do that because it has been FDA approved, why is that a problem to be a ticket Class C misdemeanor? I'm trying to understand. Help me out.
I don't know why it would be a Class C. I mean,
And why would it be? Why do you object to that being a Class C misdemeanor?
Why would I object to it? Because, you know, basically it's just like what I ran into last week with this competitor using that in a negative way in a sales presentation. Did it apply to my product? Not really. But they were still able to use it, as he mentioned before, Trailblazer. That was, I think, something that he said before. They had a thing that they put out in 2011, basically saying that you couldn't run certain assays as a preliminary assay. In other words, what they were trying to prevent was some physician or some company running an assay and then sending it off to a reference lab and basically double billing is what it basically boiled down to.
Running a what?
Running it is a double. In other words, letting the physician bill for it and then turning around and letting a reference lab bill for it. In other words, charging them twice.
Okay.
The government twice.
Okay. Well, I'm sorry I missed part of it, so I'm not quite sure I understand the objection. And so maybe Representative Toth and I can talk about it offline and we'll figure it out. So I apologize for missing part of your testimony.
His testimony is also written.
Yes,
I
did read your written.
Okay. Thank you, sir. Chair calls Elizabeth Jones, representing herself, wishing to come forward to testify against Senate Bill 992.
Good evening.
Hi, good evening.
My name is Elizabeth Jones. I am a licensed national certified medical laboratory technologist with 30 years of experience. I received my laboratory training here in San Antonio at Fort Sam Houston while I was in the United States Army, so I have a small tie to the state of Florida. I'm an independent laboratory consultant, and I work with a number of the instrument manufacturers who produce both instruments and reagents that can be used for urine drug testing. I am in opposition of SB 992. As previously mentioned, it really is a bad legislation for patients, physicians, and the state of Texas. This bill really appears to be anti-competitive in nature. It attempts to block competition. It trivializes the science and technology behind urine drug testing and has intimidated and scared some physicians into not wanting to consider their own physician office laboratory. Therefore, they have to rely on the very inaccurate rapid cup testing that's available. Once those rapid cups are done, they then send them to a reference lab who will then complete additional testing, typically quantitative and or GC or LCMS. Supporting this bill basically supports big company tactics to squash smaller companies innovatively. I both manage and consult for both clinical and urine drug screen labs. I see sales representatives all day long from manufacturers. All of them that I have dealt with represent their equipment as capable of doing qualitative and semi-quantitative testing. However, physicians may choose to do what we call a lab-developed assay using those analyzers. As a result of performing a validation protocol equivalent to the FDA's requirement for a manufacturer, a physician can set up a high-complexity laboratory and perform quantitative testing. They get a reportable number that is very accurate. They are able to treat the patient on the spot, and they do not need to send those out for additional testing to one of the toxicology laboratories. In urine drug screen physician offices and pain management, this is medication monitoring. This is not forensic testing. Therefore, there are no federal laws or state laws that I could find requiring confirmation. So a physician office who sets up their own laboratory and chooses to run a high complexity lab First of all, must meet all the federal CLIA guidelines. They are surveyed in the same manner as the reference labs and hospital labs. Many physicians choose to do that. They do charge the billing code for quantitation. There is no AMA code for semi-quantitations. So physicians do the best they can with billing and doing testing. This bill could make a decision of how to test and who to test difficult. Take it out of the hands of the physician and put it into the hands of the large toxicology labs. Previously discussed in a bill was these designer drugs, the synthetic drugs that are out there. Urine chemistry analyzers have the capability to test for those. Give the physicians in your state the ability to do that. I respectfully request that you vote no on SB 992. Thank you.
Ms. Jones. Any questions, members? Representative Schaefer.
What do you think the intent of this bill is?
That's tough. I think the intent is to stop physicians from setting up their own laboratories so that all specimens are sent to a reference laboratory. I truly believe that is the intent of what was focused here. Thank you very much.
Anyone else wishing to come forward to testify for, on, or against Senate Bill 992? If not, let the record reflect that the following individual registered for the bill but did not wish to come forward to testify. That would be Annie Mahoney with the Texas Conservative Coalition. The following individuals registered against the bill but did not wish to come forward to testify. Those would include Kristen Etter with the Texas Criminal Defense Lawyers Association and Patricia Shugart with Carolina Liquid Chemistries Corporation. Anyone else wishing to come forward to testify for, on, or against Senate Bill 992? Anyone wishing to come forward to register for, on, or against Senate Bill 992 but not testify? If not, at this time the Chair recognizes Representative Sheets to close on the measure.
Thank you, Mr. Chairman and members. First of all, Representative Toth, to get to your points,